What are we doing?
Your Honor, there is a resolution in this matter to which Ms. Wilson will be pleading to added count 2 of operating while visibly impaired, and in exchange count 1 will be dismissed.
It's an operating while visibly impaired.
That is correct.
You have her sworn? Do I have her? You solemnly swear affirm the testimony you about to give to the truth, the whole truth, and nothing but the truth, so? Yeah.
Yes.
State your name.
Angela Wilson.
Then, this is court understanding you're going to plead guilty to the charge of operating while visibly impaired. That is a misdemeanor. It is punishable by up to 92 days in jail, $300 fine plus court costs. The court could order you to pay the cost of the prosecution as well as the cost of the emergency government services, or to any rehabilitative services or community service the court deems necessary. You understand that?
Yes.
Okay. Understanding all of that, do you still wish to plead guilty? And to that charge, how do you plead?
Guilty.
In Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicant?
Yes.
What did you have and how much?
I don't.
You don't remember?
How much alcohol?
Okay, how much?
No.
What did you have?
Okay.
Tequila? Were you stopped by the police or was there an accident?
Right off the bat, we got a plea bargain in play. Count 1, dismissed. Count 2, reduced charge. That's how the system trades risk for certainty. Prosecutors secure a conviction. Defendants avoid the worst penalty. It's a courtroom chess move.
What happened?
The car rolled.
Pardon?
The car.
Speak up and run.
The car rolled over on the freeway.
It didn't spontaneously happen. What did you?
I lost control of the vehicle.
And you rolled?
Yes.
Did the police and paramedics arrive?
Yes.
Were you taken to the hospital?
Yes.
Were you given a blood test?
Yes.
What were the results?
I don't.
Was it 0.84?
The defense would stipulate 0.84, Your Honor.
Whoa, she admits the car rolled over on the freeway. That's not a fender bender. That's the full-scale crash. Judges don't take kindly to I lost control when alcohol is involved. Imagine being the judge here. Would you buy that explanation?
Do you have any reason to dispute those blood test results?
Oh, yes. I do agree.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle is visibly impaired due to your consumption of alcohol?
Yes.
Counsel, have I complied with the court with proper jurisdiction?
Defense is satisfied, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to Von Schwartz for an alcohol screening and assessment and the victim's impact channel. Sentencing in this matter will be July 10, 2024, 9 a.m.
Here's the bombshell, 0.084 BAC, just over the legal limit in many states. Small number, but big consequences. This is why it's called visibly impaired. You don't have to be blackout drunk, just impaired enough to endanger lives.
I have another bomb.
Yes, Your Honor, and I have discussed that with Ms. Wilson. She does, and I have then reached out to Community Corrections and then got the actual scram report from that company. I did discuss with Ms. Wilson. She does dispute both drinking and a tamper. She did provide me proof she was at work as a CNA during that time. Further, both in the bond violation report I received from Scram, as well as my client confirmed, she received a new Scram tether on May 28th due to it was either a software update or some sort of malfunction. She had 0 violations for the entire month of May. She got a new tether on May 28th, and then on May 31st, there was an alleged tamper that started at, I believe it was 7:10 a.m. in the morning and stopped at 10:29 at night. During that time, my client was at work. from 6:54 a.m. to 3 p.m. She denies drinking
What
whatsoever.
time did the accident happen?
I'm sorry?
The offense. What time was she at work at that point too?
So it's at 4:20 a.m. when law enforcement arrived on scene.
So early morning doesn't really matter, does it? No.
She was at work, Your Honor, and did provide me a screenshot that she clocked into work at 6:54 a.m.
And so, go ahead. I'll let you go.
We would be requesting a formal hearing as to the bond violation.
Okay, she'll get her hearing, but she's going to be remanded then. And then I already have had a violation in this case.
I understand that, Your Honor, and I understand she was remanded and served 5 days for that back in. She denies alcohol use. Quite frankly, I do believe her, and I believe that this may be a malfunction with Scram. She did receive this new tether just on the 28th. The first is when the alleged tamper occurred, and the alleged tamper ended at 10:39 p.m. at night. She still has the Scram tether on. There has been no further alleged tamper. Further, she has been to urgent care this week due to a medical issue that I won't go into too much detail with. I did provide a copy of the doctor's note that she received from that urgent care to Your Honor. We would respectfully request that if the court is leaning towards taking any action, that we set this for a bond violation hearing and that bond continue in the interim. She did enter a plea in this.
That would be fine, counsel, except for the fact that I'm now on my second violation.
312, bond violation raised. VO, studio microphone. Here comes the twist, bond violation. Courts take this seriously because bond is basically the judge saying, I trust you to behave until sentencing. Break that trust, and the system cracks down hard.
Both involving alcohol. You want me to ignore the fact that the original incident was one where she was drinking, rolled a vehicle. She's lucky to be alive. Then put her on this. She comes for discharge. She's drinking. She serves her time for drinking. I'm back, and I now have another violation.
Yes, Your Honor.
How, in what responsible world would I let her bond just continue pending you?
She denies alcohol use, and we believe it is a tether malfunction, and we're asking her to keep on the matter. She did enter a plea for this underlying offense and the alleged incident, and she is willing to face penalties for that.
Yeah, because, well, give me because first of all, changing her sentencing date, well,
June 25th at 9 a.m.
sentencing will be June 25th, 2024 at 9 a.m. We will move that up. Got a time for a bond hearing. Yeah. 20, the 25th. By bond hearing date. That's right, Kate. Well, but the 24th, we'll set a bond hearing on this matter for June 24th, 2024, 9 a.m. Ending the hearing will be set in the amount of 10,000, 5,000 cash. Remainder